Yeah, it's. Morning, have your attention, please. Just a friendly reminder to silence all cell phones and electronic devices from the meeting mode. We'll be starting in about 2 minutes. All right, thank you. Yes. Second case, sale. Oh, really? No, it's 9:30. But Turner said it was the second case. Sorry. Oh, that's her? Okay, good. Hey, you call? Yes. Add TV set. I didn't know we want to be that is more money. Also sit up with the. I feel free to be where, yeah. All right. All persons having business before the Honorable Associate Judges, now presiding of the Church of Columbia Court of Appeals. Draw near and give your attention. God in the United States and this honorable court. This honorable court now in session, please be seated and come to order.
Good morning, everybody. We have two cases on this morning's calendar. We'll get started with the first one, which is 22 CF 296 Bryant Webster versus United States.
Good morning, Your Honor. Ian Williams on behalf of the appellant, and I would like to reserve 3 minutes for rebuttal. This is a case about words matter. Is the plain meaning of the applicable rule is that once a plea is accepted, it can't be taken back without significant, it imposes a substantial burden on the defendant.
Can we ask you, before you jump into that, if you could address, since I don't believe had a reply brief from you, we don't have your response to the government's argument about waiver. Can you respond to that?
It would be awful Kafkaesque to say that a defective plea, a defective rule inquiry, Rule 11 inquiry would somehow bar an appeal of a defective Rule 11 inquiry just because the defendant has said he won't appeal, that he's waived his right to an appeal. The waiver of the right to appeal presumes that the Rule 11 inquiry is not defective.
Well, that's kind of half of an argument, but I mean, the government acknowledges that you could appeal on the basis that the plea was not knowing or voluntary, that, but not on the basis that the plea withdrawal, the trial court mangled the interests of justice calculus when deciding whether or not a plea withdrawal was warranted here. So I think they would say, so long as it's knowing and voluntary, then there's an appellate waiver. And you do have some claims that speak to knowing and voluntariness, the knowing and voluntariness of the plea, I think. But not all of your claims. Some of your claims are just, well, yeah, it was knowing and voluntary, but it was sort of a tough situation and he changed his mind. And so he should be permitted to withdraw. That doesn't sound like it's going to whether or not the plea was knowing and voluntary.
I'm not saying it was unknowing and involuntary. What I'm saying is that the Rule 11 inquiry was defective. And after that, because of that, he has the right, and he has a right to withdraw the plea because it hadn't been accepted yet.
Right, but that argument in particular, it doesn't go to the validity of the plea withdrawal. It doesn't go to the validity of the plea itself or the waiver, the appeal waiver, right?
Correct.
So there's nothing Kafkaesque about saying, intrinsically Kafkaesque, I would think you might agree, about saying, here's part of this plea agreement. One thing you will do is you will give up the right to challenge the trial court's refusal to let you withdraw the guilty plea for no or any reason. I mean, that's not Kafkaesque to say that's part of the quid pro quo. You'll give that up, you get other things.
I would disagree. I mean, it seems as though if the inquiry is defective, then.
Well, no, but I get that line of thought, but you're making a separate legal argument, which is even if the plea colloquy itself was perfectly fine, under a proper understanding of Rule 11, your client at the moment he chose to try to withdraw had an absolute right to withdraw for any reason or no reason whatsoever. And that legal argument doesn't turn on your arguments that challenge the validity of the plea itself, the Rule 11 colloquy.
No.
And there's not, I was just trying to figure out why you think it might be unfair or Kafkaesque to treat that as being something that one could knowingly, intelligently, and voluntarily give up as part of a knowing, intelligent, and voluntary plea, even though it might have been a good legal claim, but it's just something that one might choose to give up.
Well, I mean, if I'm understanding correctly, he can still withdraw his guilty plea. And the issue on appeal is the validity of, he has challenged, I mean, his motion to set aside the plea or to withdraw the plea certainly provides a basis for an appeal. I mean, if he hadn't, I would say this, if he hadn't filed a motion to withdraw the guilty plea and then somehow was presenting it for the first time on appeal, then that would be a waiver. But the fact that he filed a motion to withdraw the plea makes this an a properly appealable issue. I mean, what he waived was, if it had been a proper plea colloquy, or standard when you plead guilty, you waive the right to appeal anything except the legality of the sentence or if there's some jurisdictional issue. But what we have here is a defective inquiry. It's defective in many ways. One, because the cross-examination, using the term, your lawyer can question witnesses, adverse witnesses, as opposed to confront and cross-examine.
Well, does this mean you think only the Rule 11, the challenge to the plea under Rule 11 can be brought, but not the fair and just, your challenge to the other way of challenging a pre-sentence plea withdrawal?
I think both avenues are.
You seem to be saying that, a defective plea under Rule 11 is why this isn't waived.
There's a defective plea under Rule 11. That's constitutes a basis for finding no waiver. But before we even get to that, it was an appeal that it was a withdrawal that he had as a matter of right, based on the first argument I raised regarding the plain meaning of.
Just to be clear, so imagine your only claim in this case was, imagine that what had happened was that I don't know, the day of sentencing, before sentencing was imposed, your client said, I would like to withdraw my guilty plea. And the reason I'd like to withdraw my guilty plea is none of your business. I think I have an absolute right to withdraw it because the plea hasn't been fully accepted. And the trial court had said, I'm not very persuaded by that way of reading things. I've like the Supreme Court's decision in Hyde, so I'm ruling against you. I'm not permitting plea withdrawal. And you had noted an appeal raising only that claim. And the United States had said, there's this appeal waiver where your client agreed not to, as part of the plea agreement and in exchange for other benefits, presumably your client agreed not to take an appeal. Would you think that appeal could go forward? And if so, why?
It could go forward because he has said he's renounced the plea. The renunciation of the plea is a renunciation of the waiver of the appeal. By withdrawing, by saying, I am taking back this plea and everything that's in there, that includes.
Understood. And the trial court said that's not a good renunciation. You're not entitled to renounce in that way. And the United States' point is now you're trying to appeal to challenge the trial court's ruling. And there was an agreement where you said you wouldn't do that. And why should your client be in this hypothetical, not your client, but this hypothetical client, why should this hypothetical client be excused from being held to that plea agreement, which said, I won't take an appeal of that kind? I just don't see why that would be invalid. I understand your case is different and more complicated because your client is also raising challenges to the validity of the plea itself. But I'm just not quite sure I understand what the challenge is to enforcing an appeal waiver as against claims that don't go to the validity of the plea itself.
I mean, if that were the case, then any time a plea is withdrawn or an effort is made to withdraw a plea, it would be a non-appealable issue. There'd be no case law on it. I mean,
I don't quite see how that's true. Firstly, that would only be in cases where the defendant knowingly, intelligently, and voluntarily agreed to waive an appeal. And second, it might not be true in cases where the claim for plea withdrawal was that the plea itself and the agreement that forms a part of, of which the appeal waiver is a part itself is not valid. So I'm not quite sure that it's all or nothing in that way.
My response is, again, if the plea is renounced, the defendant renounces the plea. And the court says, I'm not going to the trial court says, I'm rejecting that argument. That in and of itself creates an appellate issue. And that overcomes any.
To follow from what you're saying, that you just can never enforce an appeal waiver when someone is appealing the denial of a motion to withdraw a plea.
That's right. He's renouncing the plea. So he's taking back everything he made in the plea.
What's the point of the appeal waiver?
The point of the appeal waiver is to make sure that there isn't an appeal following a sentence that the defendant doesn't like. Or that the defendant has an objection to. As we know, the only proper appeal that can follow a plea when it comes to sentencing is the legality of the sentence. That would be the only appellate issue. Or jurisdiction, obviously.
All right, maybe we can get into why you think your client should have been permitted to withdraw his plea.
Well, one, he had he had the right to do so. I know I have a bit of an uphill climb because of the Supreme Court's decision in Hyde, but I would say that somehow the plain meaning, if the word were entered a plea under C1C or A1C, then my client would not have the right to withdraw the plea prior to sentencing. But it's not accepted. The rules don't use the word enter a plea. It's accepted
Well, didn't the trial
So-
judge here say, I accept your plea conditional on my ultimate acceptance of the agreement?
That's correct. However, that's a contingent acceptance. That's not a full acceptance.
And can I ask you, with respect to the height of the mountain that you're facing do you agree that another component of that is that this point was not made to the trial court, that your client, that the trial court shouldn't be applying a fair and just standard, but instead should be recognizing that your client had an absolute right to withdraw without regard to whether there was any reason?
That record was not made as thoroughly as it could have been, but I.
Well,
submit
was
it's
it made
not
at all?
waived. It was not made at all, but the fact is that the argument was raised, not that specific argument, but an argument was raised, and I would submit that that preserves the issue sufficiently. As for the defect in the colloquy, I stand by what's stated in the brief about the insufficiency of the choice of words. Your lawyer can question witnesses, as opposed to the Constitution entitles you to have your lawyer confront and cross-examine. Those are powerful words. And
They're kind of legal, technical terms, though, and so in defense of the trial court's colloquy, it seems like that's a reasonable stab at explaining to a layperson what those technical terms mean.
a reasonable stab is not sufficient, I would submit. It-
Well,
a
in connection with
defendant-
that,
I'm sorry.
or in connection with that, the United States argues that interpreting how your client would have understood those words should also take into account the written plea agreement your client signed instead of the plea agreement he'd read and understood, which did use those words.
Correct. However, when a person sees something in writing and then hears a judge say something that softens it, common sense, I would submit, a layperson is going to take what the judge says and the softened approach to the Sixth Amendment as the standard, as opposed to what's in writing. And therefore,
What do you, I mean, just realistically, what misunderstanding do you think your client would have taken away from your lawyer gets to question the witnesses versus to cross-examine and confront? What visual is that painting in your client's head that's inaccurate?
the aggressive defense, the necessity of an aggressive defense to challenge.
It's the
government.
aggressiveness of the word confront. I would have thought that you get to be in the presence of the witness while they're being examined was the import, but you think it's sort of the degree to which your attorney can be hostile while questioning?
Not hostile, but firm, and
Uh-huh.
hostile might be too strong a word. That often is ineffective or goes too far. But an aggressive, confrontational approach consistent with the Sixth Amendment, challenging government evidence as opposed to casually questioning a government witness about what he or she may have seen or may have observed. That's the difference. Those are powerful words, and words matter.
Do you want to take a stab at an argument for why you think, so putting aside that the colloquy, you have a couple of arguments that you've floated already, putting aside the possibility that the colloquy, by virtue of saying question government witnesses, was ineffectual, and putting aside the hard and fast rule that you always get to withdraw prior to sentencing on an 11C1C, you do seem to have floating about and under the fair and just standard, the trial court abused its discretion in refusing to allow withdrawal of the plea. Do you want to articulate that argument?
Yes, I understand that there is some time. There was a finding of, there was no finding of ineffective assistance of counsel. I would suggest this or submit this. The fact is that the ineffectiveness or lack of competent counsel representation pertains to the timing that it took for Mr. Webster to file his motion.
Before you address the timing, and I understand the government to have acknowledged in its brief that the ineffectiveness is not, you don't have to jump through the Strickland
Okay.
prongs when we have a pre-sentencing plea withdrawal request. But before you talk about the delay, I'm interested in hearing what your argument is about the assertion of innocence.
Avoid them.
The assertion of innocence, which is one of the factors.
That, I'll be quite frank with the court, most of the cases I have found have required some statement of innocence. However, the fact that when it uses as examples, defenses that are asserted, but legal innocence, reasonable doubt, inability to prove reasonable doubt is the essence of legal innocence. And
Can I ask you, I mean, on that reading, every defendant who was moving to withdraw, unless they're incompetently represented, would meet that factor by saying, I assert that the government couldn't prove my guilt at trial. That's all you need to do. And that would just be that box checked, right?
yes, but the fact is.
And how plausible, I mean, one of the ways the trial courts, both the trial judges looked at this case was that the government's case was overwhelming even before the somewhat belated discovery of the particularly incriminating photo. So could you I mean, every defendant for sure has a right to put the government's proof to its test and to argue that the evidence was insufficient, but that seems like this is a tough case in which to suggest that there was a strong likelihood of an acquittal because of weakness of evidence.
That's not the standard, though, the strong likelihood of acquittal. And the fact is, this is a case that would have been very, very difficult to defend, no question about it, and will be very difficult to defend if the court rules vacate or reverses the trial court's decision.
I tend to agree with you. It's not the standard, but I fear that might be because the kind of assertion of innocence that you're saying is adequate is also not the right kind of assertion of innocence. I mean, if it were enough to have it tilt a factor in your favor as a defendant in plea withdrawal to come in and say, well, I assert that the government might not be able to prevail at trial beyond a reasonable doubt. If that kind of unless we're going to automatically just always mean that factor favors the defendant in plea withdrawal, then I think if that even got you into the game, then it would logically have to be that you'd start thinking about, well, is that how strong or weak a factor is that?
I think it's the fact that the standard is legal innocence as opposed to factual innocence. Or I would submit that the use of the term legal innocence as opposed to factual innocence is what's critical.
Oh, see, I would think that means, yes, I did everything that's alleged, but it doesn't actually check all the boxes of the elements of the offense with which I've been charged. You know, I allocated, I said I did A, B, C, D, E, but upon looking at the relevant charge, there's also element F, which I do not check the box of, and so I'm legally innocent of the offense. Why isn't that a better interpretation of what legal innocence means in this context?
Because someone can admit to doing A, B, and C, and D, and making all the elements, but if that admission never makes its way into court and the government into evidence at trial, and the government cannot otherwise prove guilt, then that's legal innocence. That's because of the reasonable doubt standard, as opposed to factual innocence. That's my position. And the cases that say that assert legal innocence as the standard, but then essentially require the defendant to prove factual innocence,
Well,
that denigrates the reasonable doubt.
most of our cases use this language that comes from Springs, which is a defendant seeking to withdraw his plea must put forth some facts that, when accepted as true, make out some legally cognizable defense to the charges. Do you think that fits your argument about the reasonable doubt defense?
Yes.
What facts have been put forward?
The facts don't, I mean, the fact is that the government has the burden to prove guilt beyond a reasonable doubt. That's a burden. I mean, we all know that's a burden that never shifts. It's a burden that's founded in the Constitution. It's one of the bedrock principles of the criminal justice system. And so to take that away from the defendant because who has pled guilty and wants to withdraw the guilty plea, that would undermine the whole concept of proof beyond a reasonable doubt as a legal defense. As we know, a defendant doesn't have to put on any case. And this would effectively require a defendant to make a proffer and thereby, even if he's not going to put it on at trial as a defense, he has to proffer some sort of evidence. And that totally destroys the whole idea of a defendant not having to put on any evidence.
Well, I mean, I think the rationale for that kind of an approach is that after a defendant has gone through, assume for a moment, an otherwise valid guilty plea where the defendant has acknowledged under oath guilt of the offense, that simply allowing a defendant to withdraw by saying, you know, actually, the government bears the burden of proof beyond a reasonable doubt, and I would like to hold the government to that burden, might not be an adequate reason to look behind what the Supreme Court likes to call a solemn act. So, I mean, it's a different situation after there's been a guilty plea, assuming again a valid plea. And if the issue is, well, is there a fair and just reason to withdraw? It might be that the burden on the defendant is quite a bit different than would be on the government if guilt was going to be established for the first time at a trial.
And I would submit that that can't be appropriate because the whole idea of guilt beyond a reasonable doubt is in the Constitution. The mechanism for pleading, withdrawing pleas, that's a procedural mechanism that's not constitutionally mandated. It's not a constitutional, that goes to the government's prerogatives. That helps the government, and the Constitution is designed to protect individual rights. This would go to making the government's job easier from a procedural point of view. And so that can't be a standard that this court can accept under the Constitution, under the Sixth Amendment. As to prejudice, and I understand that's a significant issue. Yes, there were victims here, of course, and having to go through a trial where they thought they'd be spared that. I'm not insensitive to that. No one should be. But the fact is, if the standard is, well, in cases where there are victims, as opposed to a drug case where there are no, direct victims, it would mean that the defendant has an inherently higher burden based on the facts of the case. In a case of this nature, as opposed to a drug case. And that would change things. I mean, that would mean it's a totally fact-intensive analysis. And more importantly, yes, there are interests that victims have in not having to relive a horrifying experience, but those yield to the rights of defendants. The Constitution says nothing about victims' rights or victims' interests. And it's very dangerous to put victims' interests on the same plane as constitutional rights that defendants have.
Thank you very much. We will give you a couple minutes for a rebuttal.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court. Mark Hobel for the United States. As part of his plea agreement, Webster waived the right to appeal his conviction. The government asked this court to enforce that waiver and dismiss his appeal. There are really two elements required to enforce an appellate waiver. First, that the waiver has to be knowing, voluntary, and intelligent. And second, that the claims on appeal fall within the scope of the waiver. Here, there's really no argument that the waiver and the plea itself were not knowing, voluntary, and intelligent. I'd even point this court to comments of Webster's counsel during the withdrawal hearing, the new counsel during the withdrawal hearing in front of Judge Beck on March 3rd, 2020, page 94, new counsel in our argument stated, did Webster go through with the colloquy and agree to it? Yes. It's more or less an acknowledgement that this was a knowing, voluntary, and intelligent waiver.
The government didn't have any problem in the trial court with the plea withdrawal motion being filed and litigated.
We didn't raise any sort of waiver defense. No, I mean, there is a proviso in the plea agreement regarding post-conviction motions, and there he waived the right to challenge the plea as a knowing voluntariness grounds or on ineffective assistance of counsel, which is similar to the scope of the appellate waiver, which allows claims based on ineffective assistance of counsel. But here, with respect to the scope of the waiver, every federal circuit that has considered this issue has found that a appeal from the denial of a motion to withdraw a guilty plea is an attack on the conviction and therefore covered under the scope of a waiver.
Sorry, to interrupt your train of thought there, but in the transcripts of the hearings, definitely in the one before Judge DeMayo, and I think also it came up in the one before Judge Beck, but there were mentions of appeal of the issues. Like Judge DeMayo says something, well, you can go ahead and, the Court of Appeals will decide this, and the government said nothing. Is that problematic? Is there an argument that you have waived the waiver?
No, Your Honor. And I'd point this court to United States v. Lee, which is a DC Circuit decision cited in our brief. In that case, the court held that the comments by the sentencing judge after the plea was entered in later hearings that the defendant would be able to appeal. Those don't negate the waiver of the appeal that occurs as part of the plea. So Lee, we think, answers Your Honor's question about Judge DeMayo's comments, which happened maybe 2 years down the line.
And just one more question, is this appeal waiver standard, the one that was used in this case?
I think the answer is yes to that question. I mean, specifically, I believe that the way that this happened is we sent over a template of our usual Rule 11C1C, and the defense here, because they were the ones who were proposing this plea, amended it to include some of the terms. I don't believe this was one that was altered. The government's interest here fundamentally, and what we bargained for, is finality. An appeal waiver is a big part of that a benefit to us.
What about the argument? I said that was the last question, but I lied. The argument that Mr. Williams makes that if this is how, if all of these claims are going to not be able to be appealed, there will be no case law. Why is there case law?
I don't know. I know that and having looked at the prior decisions involving the fair and just standard, this issue never arose. I mean, the court has never, as far as I know, looked at it or turned the judicial eye to it. And we know from the court's recent decision in Davis involving that was a recent GPS case, that the court hasn't turned its sort of eye or focus to an issue. It hasn't decided it. So in that respect, I suppose this issue of an appeal waiver is in this context is an issue of first impression here, but certainly not for the.
And can I ask you about that? Because you said, I thought, if I heard you correctly, you said that really the only things we should worry about in enforcing an appeal waiver was the waiver itself, knowing, intelligent, and voluntary. I think this is what you said, and was the and is the whatever claim being raised fall within the scope of the appeal waiver? Is that, did I hear you correctly? If we were like explaining what the
right,
the total prerequisites would be, that's what you would list.
So we're taking this from the case law in the DC Circuit, and presumptively, it is presumptively enforceable if the waiver was knowing, intelligent, and voluntary, and the claims fall within the scope of the waiver. Courts, including the DC Circuit, have recognized that there may be situations in which an appellate court will look beyond a waiver and consider an issue if there's a miscarriage of justice. If there was ineffective assistance of counsel, of course, that's a specific exception built into the agreement here. If there was a sentence above the statutory maximum, which is another specific exception that's built into the plea agreement here. But again, from perhaps I should have said at the outset, it is presumptively enforceable if it is knowing, voluntary, intelligent, and the claim is within the scope of the waiver. Those are met here, and Webster has provided no reason for the court not to enforce this waiver. And again, I'd emphasize that every federal circuit that has considered this question has concluded that a motion, an appeal from the denial of a motion to withdraw a guilty plea is an attack on a conviction, and it is waived as part of the appellate waiver for appealing the conviction. I'm sorry, that was a little implicit.
I'm just trying to figure out the idea of the word presumption here, which seems kind of an odd. I mean, it's not like a factual presumption. It's just a funny use of the term. So when we're stating a test, I'm not sure as a test it has that much appeal to me. It seems kind of opaque and a little bit off topic, since a lot of times that's treated as sort of factual in character. So you would say, but is it your view that the courts that have not created a flat rule and have kept some kind of a window open for miscarriages of justice are taking a correct approach, whether presumptive or miscarriage of justice is the phrase? You're not advocating a flat rule where, as long as the waiver itself, the appeal waiver, was knowing, intelligent, voluntary, and B, whatever claim it is falls within the scope of it, the end, absolutely, you're not advocating for that. You're acknowledging that under some rubric, there may be room for claims that would survive such an appeal waiver.
Correct. I don't think we're not asking this court to go beyond what the state of the law in the circuit in the Gillen case, which we cite in our brief, describes some of the circumstances that would prevent this from being a flat out ban, as Your Honor put it. But I just note, just to close the loop before I move on from the waiver, that in terms of this coming within the scope of the waiver of the right to appeal the conviction, that's the relief that the defense is seeking here. I just note that on page 26 of the brief, the relief requested is to vacate the conviction. So the relief that is sought here falls squarely within the scope of the appeal waiver. We would ask this court to enforce it and dismiss this appeal.
Well, it is vacate the conviction to go to trial, basically, right?
Well, that's an interesting question, because I actually don't. I don't know that I heard Webster say that that's his intention. I think that's been left a little vague here. It's not at all clear why. I think that the relief that Webster's seeking is to vacate the conviction and then leave his options open, which is really yet another reason why, even if this court were to look beyond the waiver and consider the issues on the merits, relief is not warranted here.
Can I ask you, I'm sorry, just I was looking through the plea agreement as it relates to the appeal waiver to see if I could find language that authorized the defendant to challenge the knowing, intelligent, and voluntary nature of the appeal waiver, and I didn't see it looking immediately. Am I missing it and it's in there, or do you think that the appeal waiver may have been unduly narrow if it did not authorize, but instead seems to foreclose such a claim?
So paragraph 12 of the agreement states that your client also waives any right to file a post-conviction motion seeking to withdraw the plea or challenge the conviction entered or sentence imposed, except to the extent that defendant claims ineffective assistance of counsel and or that the plea was not knowing or voluntary.
Got that, but I thought that was I thought you were arguing that's a distinct provision that relates to post-conviction motions, and that the appeal waiver was in the preceding paragraph.
Correct. So the waiver, right. So the appeal waiver doesn't specify, the appeal waiver is written very broadly, and it says including but not limited to, and it lists, I believe, several types of appeals that could be taken, but it's written broadly to suggest all appeals that are not covered within the scope of that waiver. I'm sorry, those exceptions are precluded.
In paragraph 11.
Yes.
It doesn't incorporate any claim that you are allowed to bring in post-conviction under Rule 12. You're also allowed to appeal.
No, it doesn't say that, but I think that favors our argument that.
No, I understand
yeah,
that. I was just
yeah.
trying to figure out
right.
whether the appeal waiver in what it expressly permitted was consistent with what you say an appeal waiver has to include in order to can legitimately foreclose and what it has to permit to be raised. And I just didn't see in there that the appeal waiver expressly said, by the way, you can appeal if your point is this is not about appeal waiver and I'm trying to fight through it. Now, I mean, one could say that there is the general language which says that this waiver extends, so far as such waiver is permitted by law. And if you think law requires that be an appealable issue, then perhaps it's implicit. But I was just curious, in part relative to the question of whether this is standard language, whether the appeal waiver in its express terms is consistent with what you seem to be acknowledging needs to be something that's permitted to be appealable, notwithstanding an appeal waiver.
Right. So it doesn't explicitly say that you can waive. I'm sorry, that you can appeal on the based on the fact that the plea was not knowing, intelligent, and voluntary. Of course, there's a sort of circular aspect to this in that the court would generally not enforce an appeal waiver if the plea was not knowing, voluntary, and intelligent. I'd also say that if there's any concerns with how this is written, this is not Webster's not raising the type of challenge that perhaps should have been or could have been made explicit in Rule 11, in paragraph 11, as it was made in paragraph 12. So, that doesn't mean that there's if there were such an appeal, we've already said that we don't believe that would be barred by the waiver, but there isn't here. But that's not.
Is that right? I mean, just to make sure, your view is that in this court, at least, Mr. Webster is not arguing that the plea agreement / plea were not knowing, intelligent, and voluntary. But if he were, you agree that's a claim that he could raise, notwithstanding the appeal waiver.
Right. Yes,
like one of the strands of argument in the trial court was like this was my lawyers missed this highly incriminating photo. They found it at the last minute. They come rushing to me right as we're about to go to trial. There's a highly pressured discussion, and I end up pleading not really what I wanted to do, and I got kind of pressed into it. That's that argument, if accepted factually, could be of the form of this is not a knowing, intelligent, voluntary plea. I didn't really want to do this. I got stampeded into doing it. That, if I understand what you're saying about what an appeal waiver would permit and what it would preclude, you would say to the extent that was his argument in the trial court and were his argument here, that's a claim that could be raised, notwithstanding the appeal waiver.
Right. So he would be, that would be a more or less direct challenge to the appeal waiver in the sense he would be saying, I did not knowingly and voluntarily enter the plea. And the court would need to look at that to assess whether the appeal waiver itself as part of the plea was knowing, voluntary, and intelligent. I think that's fair, but that doesn't mean that every argument that a defendant could make that I was under pressure because it was the day of trial, and I later changed my mind can be construed into a knowing, voluntary, and intelligent in this plea.
I get that, although that line of thinking suggests that the United States could have, but didn't try to bar some of the arguments you made in the trial court by the waiver in paragraph 12. And you're not trying, to the extent you didn't raise any of those arguments, you're not trying to bar any argument in this court on the theory that they were, that he should never have been allowed to raise them by motion in the trial court. That you agree, I assume. The point that the United States does not deserve.
I agree with that. We're not, we're not trying to suggest that he did anything improper by filing that, by seeking to withdraw his plea, but the trial court did not abuse its discretion in denying it, and he has waived his right to appeal that determination. I do see that I am my time is running out. I am happy to address the other issues, assuming that or address any questions the court has about the other issues in this case. I guess just to make two very high level points. As to the assuming that these claims are not waived, as to the Rule 11 issues, they're unpreserved, plain error applies. So the uphill climb is very steep here, and he has not satisfied plain errors to any of the Rule 11 claims. As to the abuse of discretion, he hasn't shown the fair and just standard. He has not shown legal innocence. Legal innocence is different from saying, legal innocence is saying, is distinct from what he's saying here, which is, I may have done it, but you can't prove it. That's not legal innocence. He acknowledges that the time weighs, that the amount of delay weighs against him. And he was competently represented in.
Can I ask you a question about that? The Judge DeMayo's findings, I guess she was trying to keep the focus narrow on the delay issue, basically, but it seems to kind of involve counsel. I feel like the counsel issue seeps into these other factors. But she said she heard the, David Benowitz, am I saying that right?
I think so, yeah.
Testify, and she heard the defendant testify about this question, whether the letter that the defendant claims to have written and that was attached to one of, a pleading. I don't think anyone really disagrees that it was written, but it was a letter that would have basically functioned as a pro se plea withdrawal, that he says that his counsel told him not to file that. And so Judge DeMayo says something kind of interesting, which is she's like, I credit both of them. And there's this, but they say things that are not reconcilable. And so she said, because I'm in a state of equipoise on this, and because it's the defendant's burden, this factor cuts against the defendant. Do you think that's a valid way of analyzing this factor?
I do, as fact finder, she could make that finding. The defendant has not challenged that fact finding here. So it's not, even putting aside the issue of waiver, it's not properly before this court. But, Judge DeMayo also said, even if, she were to credit the defendant here, he's still more than 3 weeks had passed, which is what this court has recognized as being, a time passing between a plea and an unequivocal expression of wanting to withdraw that weighs against the defendant. So, we certainly think that Judge DeMayo handled that properly here, and Judge Beck didn't abuse her discretion either to Judge DeMayo. So unless the court has any additional questions, we would ask this court to dismiss the appeal, or in the alternative to affirm. Thank you.
Thank you. Mr. Williams, we'll give you a couple minutes.
First of all, regarding Judge DeMayo's findings, I don't dispute that. That was within the trial court's discretion, and that's something that I wouldn't be able to plausibly argue an appeal should be disrupted. But what it does show is that, however much time had elapsed between the day of the plea and the statement that the plea should be withdrawn, the defendant's request, 3 weeks should not be some set and fast rule, especially when you have a defendant in custody who doesn't have the means to state, I want the plea back. It's not as though the defendant can call up his lawyer and from DC jail as a practical matter and get the lawyer out there that very day to say, I need you to go get that plea withdrawn. Or it's not as though the defendant can pick up the phone and call Chambers and say, I want my plea back. It's different when you have a defendant at liberty as opposed to a defendant who's in custody. And so I would submit that respectfully that the amount of time that elapsed was not insufficient, that the defendant did make a time, that Mr. Webster did make a timely request. Regarding the waiver issue, any waiver issue, it speaks to a tax on conviction. There hadn't been a conviction. A conviction occurs when at the time of sentencing. And the motion was made obviously before sentencing. And as to the remedy we're seeking, we're seeking a vacating of the conviction.
I can make
With
sure, I want
instructions
to make
to-
sure I follow that point. I mean, I get your point as it relates to whether what you filed in the trial court was barred by the agreement. There hadn't been a conviction at the time you filed it. I get that. But by the time you noted your appeal and now there is a conviction in a sentence and you are attacking that conviction. So I'm not quite sure that there wasn't a conviction at the time of the motion is relevant to whether the appeal waiver bars this appeal. So
We're-
I may be missing something.
We're attacking the conviction based on a ruling that was made prior to the entry of the conviction.
That's pretty much how you would normally, I mean, that's
I mean,
that's how you normally do it, right?
Of course, but it's not as though we're coming fresh. If we were, if there had been no, if we were hypothetically somehow got to this point where we could argue without it being summarily rejected, my plea should be withdrawn because I didn't feel as though I was going to get proper confrontation of witnesses after there's a colloquy about that, or I wanted to call a witness who I didn't call. That would be, something of that nature. But here there was a challenge to the plea. That becomes the issue of appeal. I mean, the error that occurred was the denial of the motion. And that's why it's not waived. And for that reason, I would ask that the court do what is requested in the brief, vacate the sentence, vacate the conviction, and remand the matter to the trial court with instructions to allow Mr. Webster to withdraw his guilty plea. Now, the implications of that is that Mr. Webster will have to go to trial. Will go to trial. He'll have a much further, steeper uphill climb, but that's his choice. And we can't fall into the habit or not into the practice of recognizing that a defendant is making a decision that we think is not the right one, turning down what might be a favorable plea because it's the defendant's choice to plea or go to trial. And it's not going to open up a floodgate, as the Supreme Court was concerned about in Hyde, that of withdrawing pleas on a lark. This isn't a lark. Ordinarily, C1C pleas are less unfavorable to the defense. So it's going to be a very rare, it's not going to open some floodgate of cases. So for that reason, I would ask the court to vacate the conviction, and remand the matter so Mr. Webster can withdraw his guilty plea. Thank you.
Thank you very much, Mr. Williams and Mr. Hobel, for your briefing and your arguments today. The case will be submitted. Second case on this morning's calendar is number 23 FM 244 Gregory Terrell Bolding versus Samuel Mack. Whenever you're ready, counsel.
Good morning, and may it please the court. Maciel Leyva, pro bono counsel on behalf of appellant Gregory Bolding, and I would like to reserve 3 minutes for rebuttal. This is a case about third-party custody standing, and more fundamentally about what section 16-831.13 means when the court is confronted with the tragic facts below that expose a vulnerable child to potential harm. If the DC Council had not enacted section 16-831.13, then we would not be here today. But the legislative history supports the two propositions at the heart of our argument. First, the DC Council preserved the court's equitable and common law powers in third-party custody cases. Second, the purpose of the Safe and Stable Homes Act is to permit third-party custody where necessary to safeguard children, even over the objections of a parent. That sets the stage for the claims brought by Mr. Bolding and the allegations in his complaint and his emergency motion, which must be accepted as true at the motion to dismiss stage. Mr. Bolding respectfully requests that this court find he has standing under section 16-831.02 and 16-831.13 for three reasons. First, Mr. Bolding's amended complaint and emergency motion for custody detail specific harms that SM would suffer if Mr. Bolding was not a party to the case. The lower court's failure to consider the facts that he pled in his emergency motion is alone a sufficient basis for remand. Second, the underlying allegations that Mr. Mack killed Ms. Ward during a custody dispute while SM was present amount to exceptional circumstances where harm is inherent. Third, the DC Council expressly granted the court the authority to craft equitable remedies in circumstances such as these. Here, the court may order a narrow remedy tailored to these unusual and tragic facts.
Those three facts are kind of cut across 02 and, 0.02 and 0.13 in a way that's a little, seems like have a gap. Because one of the requirements of the part of 02 that you have been relying on is that the child is living with the person who files the complaint at the time of the complaint, which you haven't mentioned yet. And so that's not so much necessarily an obstacle on 0.13, but on 0.02, I'm interested in how you want to surmount that piece of the puzzle.
And there, Your Honor, we're asking this court to read 0.02 together with 0.13 to find constructive living with. And so taking a step back and
What it seems like the existence of 0.13 would be an argument against doing that. If 0.13 is, provides other scenarios where the literal requirements of 0.02 aren't met, it would seem more natural to read 0.02 literally and then have your client need to rely on 0.13. Why do the existence of both of them suggest that 0.02 should be read constructively rather than literally?
Two-part answer, Your Honor. First, we do have a second basis for standing, which is exactly what you articulated, which is a cause of action that would arise under the court's equitable jurisdiction. But since we're focusing on the second path to relief, which is constructive living with, if you were to read 0.13 together with 0.02, there what we're looking at 0.02 AC in the living with part, so constructive living with. There what we're looking at is a plaintiff who has pled exceptional circumstances, has pled potential harm, and the living with is being missed by a matter of days. It's being missed because he complied with a government order. And now the suggestion that he should be penalized for that when he didn't sit on his rights. He went pro se and filed a complaint for custody in January 2021, mere days after he didn't have the child. And this was
Well, he only had the child for mere days. I mean, to say he missed it by a number of days sort of misses the fact that he had custody of this child for about 8 days. And then I believe there's a 13-day delay. Now, if this had been a 6-month residence with the uncle, then he'd be in the statute because the statute says if they had custody of him for 4 of the previous 6 months. So days wouldn't matter. But when you're talking about 8 days of living with the uncle and then petitioning for 2 weeks late, it's not so sympathetic to say he just barely missed the deadline. He barely had a window to file anything.
And Your Honor, that brings us in this is where Pleasant is instructive. So we look at Pleasant and we see that a plaintiff who's very similarly situated to our own. So in plaintiff, the grandfather took custody after the mother was killed by a third party, pled exceptional circumstances after having the child for 8 days, and was facing a custody dispute against an available parent. And the allegations that the plaintiff made in Pleasant was that the father's history of domestic violence was instructive and exposed the child to potential harm if the father were to take custody. And in Pleasant, like here, the grandfather only had custody for days, less than 10 days before filing for custody. And there the court, upon remand from this court's opinion, did find exceptional circumstances. So really what's setting us apart from
I'm sorry,
Pleasant.
just to be clear about the holding, we didn't say anything about whether
We
or
didn't.
not the child was living with the grandparent in Pleasant. But you're relying on a remand, that there was a finding on remand that those 9, and I don't know, did the 9 days extend? I know that's when the petition was filed after 9 days. I don't know if he lived with grandpa for more than that. But you're relying on a trial court finding that that was enough to establish standing under .02, even though that was filed while the child was living with the grandparent.
It was filed while the child was living with in those less than 10 days. And here you see a circumstance where Mr. Bolding could have been similarly situated if not for complying with the government order. So that, in a matter of days, is what's setting Mr. Bolding apart from Pleasant, where you have the death of the mother, an available parent, and allegations that were the available parent to take custody, there would be a concern of potential harm to the child.
But the
And-
two steps are we'd have to agree with the trial court, which is not something that we've analyzed before, about whether or not this short of a period constitutes living with somebody. And then we'd have to extend that agreement to situations contrary to the statutory text where the child is not in fact living with anybody, but had at some point in the past, even if a de minimis amount of time. Is there some limiting principle? Like when I send my kid to summer camp, are they living with the director of the camp and can they petition for custody of my children?
No, Your Honor, and that's where the court's discretion really comes into play, where exceptional circumstances prong is asking, are there assertion of circumstances? Is there a potential for harm living with? So your question to be, is 1 day enough? Is a few days enough? Is sending my kid to summer camp enough? That's not living with as as defined by the DC Council here. The DC Council uses living with to mean like the person has taken custody, is responsible for the caretaking of a child in a way that's not just at the consent of the parent sending them away for a limited period of time, which is why the summer camp example wouldn't be one where you could then have the summer camp counselor parading into court and making an argument that they should have custody, because that's what the DC Council was concerned about. The DC Council was concerned about strangers coming into court under the exceptional circumstances prong and making an argument of custody is better with me because. And that's not what Mr. Bolding is doing here. He's specifying what he should specify, which is potential harm to the child after the child was allegedly present when Mr. Mack killed Miss Ward. And at best,
I mean, I would think potential harm to the child means something along the lines of neglect. There's no allegation of neglect, right?
there has not been a filing of neglect in this case.
Uh-huh. And so the allegations of harm, I mean, I think they're phrased in a couple of different ways. One is sort of alienation from the maternal family, which seems like an impossibly broad standard of harm. You know, that if that were the standard of harm, a stranger really could petition and say, I would like custody of your child because otherwise they don't, get to, benefit from all the greatness of being around me would bring to them. So I don't understand how that's a really plausible meaning of the statutory requirement that you have to show that harm would befall a child if it's just, they'd be better in my presence. Is that, am I misarticulating what you think harm amounts to under the statute, or do you want to?
That's not the only harm that we would point the court to here. We'd also point the court to the harm that is pled in plaintiff's emergency motion for custody, which that the child may be suffering PTSD as a result of being present for the interfamily offense per the allegations.
But custody with Mr. Bolding wouldn't prevent that harm, which is part of the statutory requirement. There's extraordinary circumstances that would require custody to the third party to prevent harm. The PTSD and being present for the murder, that doesn't prevent Mr. Bolding having custody, can't unwind that clock, right?
It's not so much about unwinding the clock, Your Honor, but about understanding, okay, that already happened. We can't change that he was present, but what we can do is put guardrails in place so that he can be protected from that point forward, so that he has a therapist that he can speak to, so that we can understand in his interactions with the father, is he now fearing for the about his safety? This is something Judge Israel raised, what are their interactions like? Has the child been able to cope with what's happening? No one here is suggesting that the child should not have a relationship with the father. We just want to make sure that the child is protected in the course of those interactions. And by Mr. Bolding filing for custody, what he's saying is, I am asking this court to hear my custody claim, listened to my concerns about potential harm to the child if there aren't any guardrails for his ongoing interactions with his father. And my presence here in this court allows the court to do that. And we actually saw that play out because Judge Israel was able to appoint guardians ad litem, sua sponte. She had them conduct all these different types of checks. And so the question is, where the third party custody statute is the paramount concern is the safeguarding of SM from harm. Are we doing that when the case is being closed off at the standing stage? And is that really what the DC Council intended?
Can I ask you to, back to living with, and just how transitory the living with could have been. So imagine that it was really the role that the neighbor played, which was to have the child overnight before Mr. Bolding took custody of the child. So imagine Mr. Bolding had the child overnight, and then CFSA had come in and intervened, and things had happened as they did. So overnight would be fine. I assume you would think it's not 8 days, isn't the magic number, assuming he had filed either while, before CFSA took custody of the child or transferred, caused physical custody of the child to change, or was involved in that. Or assume that he wasn't able to file during that period, but then he filed very promptly thereafter, you would say he still would have a claim. It's the 8 days is not magic. 1 day would have been fine as far as you're concerned. Is that right?
8 days is not magic. Overnight may be enough. I think these custody cases are always intensely fact specific. And here what we have is
We're just trying to figure out what the word living means. So I don't know I mean, I guess that could be, that's a statutory interpretation, legal concept. And then you'd have to figure out and compare the facts of any case to whatever you thought living with requires legally. But I'm trying to figure out less about the facts and more about what you think living with would mean. It sounds like you're not 100% sure about overnight. That seems to imply that if he had taken the child home for a few hours but hadn't had the child overnight, you wouldn't think that was living with, or you'd be more unsure it wasn't living with within the meaning of the statute.
I think that is more of a borderline case than when you have 8 days, particularly when the facts are that it's in the immediate aftermath of the mother's death. And so you have someone not caring only for the physical safety of the child, but the emotional safety of a toddler in the immediate aftermath of his mother being killed. And so what you're providing there as far as caretaking is more than you would expect of a babysitter who's keeping a kid overnight. This is just ultimately a case of really tragic circumstances where the concern has to be safeguarding SM, and where Mr. Belding.
Can I ask you about that? Judge Deal asked you a question about whether there had been an allegation of neglect, and it seems as though CFSA never filed a neglect petition. I guess I had read your brief and the amicus brief of DB Leap to be arguing that, taking as true the assertion that Mr. Mack killed the child's mother in front of the child, that itself is neglect. So I had, do you think that is itself neglect?
We don't have a representation to make as far as the neglect standard. What the statute asks for in standing is harm, and we think there is inherent harm.
I get that the neglect standard is different from the standard you're operating under, but in part, I guess I was wondering whether efforts were made by Mr. Bolding to encourage CFSA or take steps to cause CFSA to bring a neglect petition arising out of the alleged fact of the killing of the child's mother by the father in the presence of the child.
We don't have the benefit of the record on that point because, again, this was cut short just at the standing stage. We haven't gotten to parental presumption, which is where Mr. Bolding would have the obligation of showing by clear and convincing evidence that the parental presumption should be rebutted. And it's at that stage that you would expect to see the sort of evevidence that you're suggesting, Your Honor.
Well, that's actually a different, I think that's a different question about what ultimate custodial determinations would be made. My question was more about what would happen in a neglect proceeding, which wouldn't then be about parental presumptions and instead would be about parental conduct and the abuse and neglect standards. But it sounds like you're not taking a position about whether the conduct here would properly understood, the alleged conduct here would properly be understood to amount to neglect.
That's correct, Your Honor. We don't have a representation to make on that point. But as far as whether CFSA might have seen some potential harm or been thinking about a neglect action, one indication is in their family team plan, where they list, quote, safety factors, immediate danger. They state, we think the children/teens are not safe because 12/31/2020, the agency was consulted regarding allegations for Mr. Samuel as it relates to Ms. Erica Ward pending criminal investigation. So we know that in support for Mr. Bolding's claim here that there is potential harm, CFSA was in alignment in identifying potential harm. And this goes all the way back to what is it that Mr. Bolding has to show? And we can see that he was not living with the child at the time that he filed the complaint. Well, but there are exceptional circumstances and there are specific pleadings as to the harm that might befall SM. And that harm is the emotional turmoil of having to not only be present for when his mother was killed, but the fact that his father was the actor in that case, and that now he will continue interacting with his father without any sort of guardrails in place. And that is the potential harm that Mr. Bolding was pleading here. And when we read that together with 831.13, what we need to understand is, okay, what does 831.13 mean? And if it's ever going to mean something, it has to mean something here where the equities are sort of screaming out for a situation where we can focus on SM safety and address the harms that were pled in Mr. Bolding's complaint. Because right now,
Why do you say that? I mean, I appreciate sort of if you're focusing on Mr. Mack, I appreciate why you would say there are reasons, there are equitable reasons why Mr. Mack should not really control the custody of his daughter, and then other people should have some insight into that. What I haven't quite heard you say is why that somebody should be Mr. Bolding. I mean, Mr. Bolding is a relative stranger to this child. I mean, I appreciate that he's an uncle. He's an uncle who it seems like had not had any involvement with child life for a couple of years. I appreciate there are complaints about that wasn't of his choosing. But do you have any case at common law and equity where somebody who could be fairly described as a relative stranger whose extent, I mean, most of those cases are de facto parents where they're living with somebody, they're caring for somebody for extended periods. I have not come across anything that treats an 8-day tenancy with somebody as giving them sort of equitable cause to petition for custody at law or equity, or in the cases. What's your closest thing?
so the two cases that we would point the court to here are Shelton and Rutledge, which closely mirror not just our case, but Pleasant. So there's 3 commonalities. The first is mother dies and the third party takes custody, that third party in Shelton and Rutledge being a grandparent. The child then goes and lives with the grandparent, similar to our case and Pleasant. And the grandparents in Shelton and Rutledge allege potential harm would befall the child if the father were to take custody. The harm in Shelton is unsafe housing. The harm in Rutledge is a history of parental indifference. The harm we see in Pleasant is a history of domestic violence. And similarly here, it's not just a history of domestic violence, which we detail in our briefings, but the ultimate intrafamily offense where at best, Mr. Mack pulled out a gun on an unarmed Miss Ward during an argument, knowing that there were children in the home, including SM. And that just shows a disregard for the child's safety. And this court most recently said in JL v. LB that court should, which I should note is a third party custody case, that courts should exercise considerable caution before granting visitation or custody rights to a domestic violence perpetrator. And here, when we look at the record, there is just not enough, I submit to this court, to be sure that the lower court did give the type of careful consideration that is mandated when a domestic violence perpetrator has the potential of taking visitation or custody. And that's not to say that they won't eventually, right? That will be worked out at the best interest stage. But there's just has to be some sort of explanation on the part of the lower court, some findings to that effect. And we just don't have that in the record here.
I guess, could I ask you, with respect to any of the common law cases or equity cases before the enactment of the statute that you rely on, are any of them ones where there remained in the picture a custodial parent as to whom no neglect proceeding had been started?
In both Shelton and Rutledge, Your Honor, I think.
My question was ambiguous, so I'm sorry to interrupt, but just to clarify, what I mean is someone who had a legal right to exercise custody over the child at the time the third-party complaint was filed, and as to whom no neglect matter had been raised. Is there a case that takes that form?
Your Honor, I would submit to the court that in Shelton and Rutledge and Pleasant, there was no pending neglect action.
Right, and did there exist a parent, an already existent parent who had a legal right to custody of the child?
Yes, in all three of those cases, as in ours. And
And-
there, the court reached the merits. There, the court said, okay, what we're seeing in front of us is credible allegations of potential harm to the child, an available caretaker, exceptional circumstances where a parent has been murdered. And there's allegations that, this third party needs to step in just to have the guardrails in place. Our paramount concern is protecting the child. And so in these common law cases, we're going to at least get past standing. We're going to go to the next stage. And we posit to the court that here, the equities being what they are, we should again find that in our powers and equity, the court may provide an equitable forum so that the harms that Mr. Bolding has pled can be investigated and SM's well-being can be safeguarded.
And as a matter of what you think the scope is of the equitable cause of action that this would be an instance of in your view, are there any minimum requirements? So imagine that rather than Mr. Bolding, it was a neighbor who had never met the child and who had heard about the situation and thought, this is a terrible situation. I am an empathetic person. I'm going to file a complaint for custody because all of the other allegations are true. This is a child that needs protecting and no one else seems to be standing up. No one started an elect petition to try to address the problem. So somebody needs to do something. The court needs to do something, and I am willing to offer myself up. Is that in your view within the scope of an equitable cause of action, or do you think there are some kind of prerequisites about a connection between the person seeking equitable parentage, if you want to call it that, and the child as to whom parentage is sought?
That situation feels different for a few reasons, Your Honor. The first is precisely what the DC Council was concerned about was like complete strangers coming into children's lives and trying to make arguments that, they would be a better caretaker than whatever a neglect proceeding or whatever the parent would like for the child. And so
Before you go to the several, just focus on that reason first. I don't mean to interrupt your other reasons, but focusing on that one first. That answer seems a little bit in tension with what I thought your general position was. So I just want to flag that and see what your response is. I had thought your view was that the statute really doesn't impose limits on the equitable cause of action that pre-existed. It just kind of creates its own set of things that you don't have to hop through the hoops of equity in order to show your standing. But now your answer seems to be that interpreting the scope of the cause of action and equity should be influenced by the requirements that were imposed in 02. Am I missing what you're saying now, or did I misunderstand what you were saying before, or is there a third mistake I'm making?
Your Honor, to clarify the point I was trying to make is at a minimum under 831.13, you would have to find a similar case in common law or equity. I have not come across any case where a stranger acted in the way you just described, where they tried to step in. The only cases I came across where the court actually provided a forum is one where a family member who had taken refuge of the child, then went to the court and filed in the matter, like in Shelton, Rutledge, and Pleasant. And so apologies for not making that point more clearly, but it was only to say a stranger is what the DC Council is concerned about. We also don't have anything in common law to suggest that that is permissible. And so where you have those two things together, it becomes much more difficult. And I take, Judge Deal, your point that you see Mr. Bolding as a stranger to the child. The child at the time that this traumatic incident took place was only 3 years old, had lived a very short life, but essentially for a third of his life had a relationship for Mr. Bolding because it was until 11 months that Miss Ward had custody. And so that's another lens with which you can view the relationship. And again, we see Mr. Bolding as being more in line with the parties in Shelton, Rutledge, and Pleasant, and that he was a close family member of the deceased who took custody in a time of crisis to try to provide the child with some safeguarding.
So did we just get BJ VRW wrong? I mean, it sounds inconsistent with your position. So why did we not? I mean, not only did we say no standing under .02, but they said or any other provision of the Secure and Safe Homes Act. So was that a mistake?
No, Your Honor,
Okay.
where we see BJ as distinguishable from this case is that BJ was concerned with, I am the better caretaker because that was really the argument that they were bringing before the court. It wasn't an argument grounded in harm, which is what is required to make a showing under both the
That's not
common
really
law.
what we say. Where are you getting that from?
Apologies.
That's not, we don't say anything about like a failure to show harm. Like the word
Mhm.
doesn't even appear in the opinion. So where are you getting that from?
Our
I mean, we say BJ doesn't have standing because I'm sorry, because she doesn't check any of the boxes in 0.02.
Mhm.
I think, and then says, and no other provision of the act gives BJ standing either. So I don't. I suppose you could say, well, they didn't consider a situation where harm was being alleged, and maybe that's true, but it didn't seem to be a limiting principle in BJ itself. We didn't talk about a failure to show harm or anything like that, did we?
You didn't have an opportunity to because the plaintiffs didn't bring that before you. So the plaintiffs focused their arguments there on, we think it's in the best interest of the child for us to take custody. We think we would be better caretakers because X, Y, Z. And so when confronted with those arguments, Your Honor, this court found that's not sufficient. That argument of,
But not because of a failure to show harm. I mean, that's kind of the missing piece if you want to reconcile your case with BJ.
Mhm.
BJ didn't care about harm. And that can't help you.
BJ was, this court was confronted with where we think that it would be in the best interest for the child to be with us. Can you give us a free floating cause of action, a fourth path to standing under 831.13? And this court said no. 831.13 means something, but it doesn't mean that you have a freestanding cause of action where you're pleading that the best interest of the child would be served by you being the caretaker. And so to try to make my point a bit more finely, I'm differentiating that from what Mr. Bolding is bringing forth here, which is I fall under the 831.13 when read together with 0.02 because I've pled exceptional circumstances, I've pled potential harm, and I would be situated just like the grandfather in Pleasant were it not for CFSA intervening, was it not for me complying with the government order, were it not for me not understanding as a pro se party what it would mean to relinquish custody in that manner.
Can I ask you, I should have done this, but I haven't, so maybe you have. Looking at BJ, we do have the language that Judge Steele referred to that said that the decision that was being sought there was not authorized by, one provision and then or any other provision of the statute. I don't see that we specifically referred to 0.13. Do you know, I just haven't gone back to look at the briefs in BJ, whether that provision was brought to the attention of the court and was part of the argument about what the authority the court should have been considering in BJ?
My understanding, Your Honor, is that the parties did not fully brief that issue for this court's benefit. So this is.
I mentioned the word fully in that. Do you know if it was mentioned in the briefs or you're not sure?
I can make your representation upon rebuttal. I can check for you.
Thank you.
Your Honors, thank you.
Okay, thank you. We'll give you a couple minutes on rebuttal. Thank you.
Morning, Your Honors, and may it please the court, James Wade on behalf of Applee, Samuel Mack. The trial court correctly determined that appellant failed to establish the requisite elements for third-party standing pursuant to 16-831-02A1C and could not otherwise pursue third-party custody under 16-831-13, the savings clause. And this court should affirm for three principal reasons. First, the plain and unambiguous text of the standing statute precludes standing because appellant was not living with SM when he filed his complaint, and appellant provides no authority whatsoever to support its request for a novel constructive standing, constructive living with interpretation.
Can I ask you how literal you would be? I mean, imagine that a child, both of a child's parents have died, and somebody intervenes and takes care of the child without any real formal arrangements for a couple of months, and then informs some other family member, I'm about to file a complaint for third-party custody, and that other family member doesn't want that to happen, and just runs in, kidnaps the child, runs off. So then at the time that, you know, the complaint hasn't been filed yet, and now the person is like, I was going to file a complaint. Now it seems like the child is not living with me. Would you say you're out of luck under O2, or do you think that there's any leeway under O2 for not entirely literal interpretations in unusual circumstances such as that hypothetical?
I think that might be the case for this court to address in a case that actually had exceptional circumstances for that portion of living with. And I think that addresses the court's questions about what does living with mean? I mean, at the least it means, you know, under somebody's roof, which Mr. Bolden concedes that he doesn't even fit that definition. But it also means something more than just under somebody's roof. It means living with, and as we put in our brief, residing, some sense of permanence. So for instance, if I have my children and they go spend the night at a neighbor's house, and if there were a cause of action, just to say that I could not file a petition for some hypothetical reason because the child is not currently under my roof at the time, that wouldn't make any sense. So I think the reverse would be the case as well. So if you have some kind of third party that had parental responsibilities, had been living with the child, and then there was a kidnapping, and that moment, the individual was not under the roof, or it wasn't living with in terms of under the roof, I think there would be a claim there. There would be a completely different situation than what we have here.
Just if I'm taking an aspect of your answer, you seem to be acknowledging that at times someone could be viewed as statutorily having a child statutorily living with a person, even if at the time the child is not physically present, and the person has like not even necessarily any knowledge of where the child's whereabouts are, if the connection between the amount of prior physical living had been enough and the legal rights to have authority over the child, which might vary depending on which hypothetical you were picking. So what do you think, if you're going to tell me, here's what living with means, maybe this is a way of cutting at it. Could you tell me what you think, if X is true, child A is living with person B? What is it that we should be looking for about where the child physically is at any given moment, and what authorities the person has over the child at any given moment to give content to that phrase living with?
Right. I mean, I think it at least means something more than just providing basic like food and shelter for a kid, in the sense that you have, you know, a babysitter or some type of neighbor where there's a situation where a kid spends some days with somebody. Because again, you have, and with my hypothetical, you have a legal, you know, I'm a legal parent. So in your hypothetical, you don't have this kind of legal sense, but in your hypothetical, you do have somebody that is taking over parental responsibilities, kind of like what you have in A1B, for instance.
Well, when I was little, we used to sometimes go to my grandmother's and spend a couple weeks there in the summer.
You're not living with your
We were
grandmother.
not living with, you would say my grandmother in that hypothetical, if she lived in DC and we're still alive and I were a minor, would not have the ability to file a third party complaint, because vacationing with a person with the consent of the parent, even for a significant period of time, like a couple of weeks, would not constitute living with, you would say.
I mean, yes, I agree with that basic statement. It's not living with, but then you have a whole lot of assumptions that have to be put in place to even get you to where the hypothetical kind of could potentially fit in a mold that Mr. Bolden would want. Like you're assuming that there's consent between the parent to go live with your grandmother.
Understood. That's very removed from the facts of our case. But mostly what I'm trying to do, I guess, is figure out how plain language your point is. Because if living with means like, you know, physically staying with at the time of the complaint, then it seems like Mr. Bolden is just pretty much flat out. But if you're acknowledging that living with is a more complicated concept, and it can not apply to people who have physical, you know, for example, the hypothetical of the grandparents, if the child is not living with the grandparents, although the child is residing with the grandparents who have a pretty substantial parental, in local parentis authority over the child, perhaps with the legal parent's consent. If that's not living with, then it seems like living with is not so much a simple concept of, oh yeah, it's obvious what it means. Just apply a ordinary language, plain interpretation of what living with means. You live where the child lives where the child is sleeping at night.
I mean, I
It
think
seems more complex than that.
I think you have, for purposes of this case, I mean, extending some judicial restraint because you don't have that scenario here. So the court doesn't have to address, that type of permutation. But I think so that's at the base level is that, even if you assume that living with is just the basic under the roof of another individual, then Mr. Golding doesn't fit that. So I think that.
I thought you were acknowledging that it sometimes extends more broadly than that.
No, yes. I
guess I find it a little hard to say, I don't know what living with means. I can't tell you much about it generally, but I can tell you this is not living with because ... I need to kind of have a sense of what are we focused on in living with? What does it incorporate about? How, to what extent is it determined entirely or in part on actually physically where is the child each night? To what extent does it depend on what authorities somebody might have through parental consent or in law, otherwise? I guess I
think ultimately we rest on our briefs where we define, under Webster, it defines living with as reside requires some type of permanence. And I think that's where we stand in terms of living with means that you have some type of permanent relationship here. And that's why there's the subsection about babysitters can't, if you're getting paid, for instance, and you're, babysitters, they can't apply for third-party custody.
permanent seems tough just because B1 says lives with the child for 4 to, another way of getting there is if the child has lived with the claimant for the last immediate 6 months, which wouldn't necessarily mean permanent.
Well, when I mean permanent, I mean some type of significant relationship that you have. I mean, if you look at this, the way that the statute is built, you have the consent of the parent, of course, that makes sense. That's longstanding. And then you have part B, which is, well, you have 4 to the last 6 months and taking over some parental responsibilities. And then C, you have, okay, where we have this living with component, and then you have to provide some exceptional circumstance that necessitates, having the child stay with the third party to prevent some type of harm. So
Just to clear, so if I had been sent by my parents to my grandparents for a 4-month period, but from May to September, would you say under A1B1, my grandparents could file a motion? They would have standing to file a motion. They might not be able to prevail, depending on. My parents were one of the parents, so they would not have been able to prevail, I assume. But
well, that's why A1B1 is termed a little bit differently. It says lived in the same household as the child for at least 4
understood
for the last 6 months. So even then of course, your grandparents would be able to fit under that statutory.
But you don't think lived in has also some additional requirements other than kind of the ordinary sense of residing together? Doesn't have a permanence, some additional overlay of permanence?
No, I think when you have to, because you have to take B1 and B2 together, right? You have the residence, somebody's living in the same place as somebody else, but then you also have the primarily assume the duties and obligations for which a parent is legally responsible, and then food, shelter, education, medical, all those things. So again, I don't want to make it seem like that's entirely just academic, but in this situation, we have Mr. Bolding, who did not have in any sense of living with. Again, as Judge Steele pointed out, this was essentially a stranger from 11 months up until this 3 years old. It didn't have any contact whatsoever, as far as the record shows, and came in for 8 days and then was without the child for 13 days. And appellant has backed off any kind of insinuation that CFSA acted illegally in any kind of way. So voluntarily ceded control to the extent that he had control of SM over to the adult sister.
Can I ask you a question about the role of CFSA in the changing of physical custody from Mr. Bolding to Ms. Mack? An argument today, and I meant to follow up on this, but I haven't had a chance to yet. I think that Councilor Ms. Bolding referred to what CFSA did as having ordered Mr. Bolding to provide custody to Ms. Mack. Do you agree with that description of what CFSA did, or do you view it differently?
No, absolutely not. What CFSA did was what they have the authority to do under the chapter, Title 4, Chapter 13, and under the neglect provisions, which is they undertook an investigation as to whether or not there was neglect in this case based on the allegation against Mr. Mack.
What would be the consequences if he did not turn over the child?
Well, I think that Mr. Mack, being the only person with a legal right to the child at that point under 22-101, would have been able to call the police, or even CFSA could have taken control of the child. I mean, under the taking into custody for neglect, you can, if the child is run away, for instance, the police can go and take custody of the child. So again, he has the legal right. Mr. Bolding had no legal right whatsoever to SM. And so I think that I mean, even though that they claim he did, he had no legal right.
Conversely, you're not saying that anything Mr. Bolding did in the 8 days that he was had physical custody of the child was itself unlawful.
No, we're saying that he had physical custody of the child at the time. There was a voluntary meeting, the family team meeting that was conducted by CFSA, and you have the team meeting through the appendix, and Mr. Bolding was a participant. There were numerous parties, whether or not they were interested parties like Ms. Ward's friend, or whether or not it were the parents of the individual children that were at stake. And numerous people stood up and said, well, I'm willing to take this child. I can't take this child. Ms. Williamson said she would take all the children. What CFSA discussed with the entire group was that Ms. Mack, the adult sister, wanted to take the child, had consent and the affirmative request by Mr. Mack to take custody of the child. And Mr. Bolding, along with every other person in the meeting, signed off and agreed that that was what was going to be the plan. And there was no type of objection.
You make a lot of that and a lot of that point in your brief. If it were not so, like if he had made more of a fuss, and this sort of implied in your argument, more of a fuss, tried to keep the child, kept speaking up about wanting to be the person the child was placed with. Is there a point at which, under your analysis, that could get him into the lived with category, notwithstanding the, not actually being there?
No, it wouldn't have mattered. I mean, I think that between the complaint and even if you assume that he did not want to see control over the child, that is of no moment in terms of how we deal with the threshold issue of standing. Again, he had no legal right to the child at the time. That was solely within the purview of Mr. Mack. And so even if he had raised all kinds of objections, then, there could have been and kept the child for some reason, then there could have been other remedies and legal remedies that Mr. Mack could have taken or CFSA could have taken. But none of that, again, not to say this is all academic, but none of that happened. What ended up happening was that Mr. Bolding voluntarily ceded the child over to the friend. The friend provided the child to Ms. Mack, where he has been ever since. And even to the extent that they're claiming of some type of extraordinary circumstance to prevent harm, there is no harm to prevent, because he cannot claim that being in Mr. Bolding's custody would somehow prevent a harm from where he is right now. And where he was at the time that he filed the petition was with his adult sister, who in all accounts throughout all the protracted proceedings that took place has been nothing short of a fantastic caregiver.
Can I interrupt and ask you a question about extraordinary circumstances? Is that the word? Exceptional circumstances. You argue that that Mr. Bolding's view of exceptional circumstances essentially boils down to like a best interest analysis or something. And it's clear, our case law makes clear those analyses need to be separate. That's plain. But if that's the case, what is relevant to the exceptional circumstances analysis? what would be sort of the paradigmatic example?
I mean, I think a good example would be, say, for instance, say you have a third party that currently has custody of a child. And I think this is also why you need both factors in order to have standing, that currently has custody of a child. And there is all fighting and abuse and whatever it may be, there's trauma at the home of the child, where they live at. And to prevent the child from going home and if the father says, for instance, if you send this child home, I'm going to whoop him. He might not make it out alive, something of that nature. And so that way, the third party who has custody of the child can file a petition and claim that, okay, well, the child is living with me, I'm providing like a parent. And also to prevent some type of harm, I know that this father is going to, or the mother, or whoever it may be, is going to inflict some type of physical harm or emotional harm or something to that nature.
So the
Actually,
death of, I'm sorry, the death of a parent doesn't fall within that primarily because of the lack of evidence of harm?
Well, the death of a parent in and of itself does not count for prevention of harm to the child. And again, I think that this is where you have the neglect system that has been longstanding and comes into play, that CFSA investigated and determined that the facts did not warrant a petition to say that the parents are unfit or in some type of way that they're neglectful, they're not providing for the child, they're going to subject the child to some type of abuse. So I think if you have a scenario for which the child would actually be in danger if they were to go back home in some way, and because the third party already has some type is taking care of the child and acting as a caretaker.
And I want to ask you about that because when you were answering Judge Beckl's question, you were referring to the third parties having custody of the child, which isn't the statutory term
Living
here, and
with.
it's an ambiguous term. So I just want to make sure what you meant. You meant living with, in whatever that means in the meaning of the statute.
Yes, I meant living with, not custody.
But wouldn't the neglect, in the hypothetical where you agree there are exceptional circumstances, the neglect system is in theory available to prevent that as well? Yet this seems to be a second route to address the situation.
Right. I mean, admittedly, I haven't thought all the way through all the different type of permutations there could be a potential harm to the child, and the neglect system wouldn't be an avenue for that. But because it would be in a way that the neglect petition hadn't been filed. So if you have a situation where a child is under somebody's living with an individual and CFSA is not involved, for instance. And so, for one reason or the other, they're not doing an investigation or there's no petition that's been filed. You can have a scenario where there could be some kind of similar dangers to the child or potential harms to the child that could be inflicted.
And I thought I know you dispute whether this was adequately presented in the complaint or at all in the trial court. But the argument made on appeal, at least, and maybe to a degree in the opposition to the motion to dismiss for lack of standing, is that this case is like what you're describing in that there are risks of harm to the child in allowing the child to be in the current situation, which is being cared for by a custodian who is allied with the person who allegedly killed the child's parent in front of the child, that itself is a risk of harm to the child. It's psychologically damaging and the like. I know that one of your arguments is that wasn't adequately presented in the complaint. So I get that. But assume that the complaint had said, here is our argument of exceptional circumstances. It will be psychologically devastating to this child to be, in the custody of someone who's allied with the person who, according to our allegation, murdered the child's mother in front of the child. And here's what's happening about that in terms of the control of that person, the father over the way the custodian is operating. And here's our psychological evidence that that's really damaging to a child. Do you think that that's just assuming it were adequately alleged and supported? Do you think that there's something intrinsically deficient in that kind of showing to make exceptional circumstances? Or is your point more, it just wasn't, the record wasn't made on any of that? Or both?
I think it's kind of both. I mean, the record certainly wasn't made, but also what the statute requires is that the complaint or motion shall specify in detail why the relief is necessary to prevent harm to the child. So you have, even if you take the motion to for emergency custody into account, you have, it's entirely speculatory. It says that we believe, or that the child may, I'm sorry, there were two essential allegations. There was one that the child, there may be an imminent danger and may be taken out of the district pending his father's trial. And the child could be going through PTSD because of potentially witnessing or witnessing the death of his mother. And first of all, that doesn't meet any type of specificity or detail beyond just kind of conjecture as to what possibly could be going through the child's mind. But again, and I think the court pointed this out, was that, well, what about Mr. Bolding having custody would necessarily prevent
Well, that
any harm
seems-
to the child?
But I don't know, prevent all harms, but if assume that an adequate record had been made, that was a harm that the child would be subjected to under the custodial arrangement that existed. If Mr. Bolding said, well, I'm not going to be doing that, then I would think it'd be pretty natural to say that, I don't know, it'd be necessary, but it would be at least one way of avoiding that alleged harm would be give custody to me. I'm not going to be subjecting the child to the control of the person who, according to my factual assertions, murdered the child's mother in front of the child. So I'll fix that problem.
Right. I mean, if this case involved facts that were properly pled, for instance, provided that specificity, provided the detail, and wasn't based on conjecture, then right. I mean, I think then you could have an extraordinary circumstance, or I'm sorry,
Right.
exceptional circumstance.
And I know
which
you have this, that's independent of your living with problem.
Right,
I understand
again-
that. I understand that there are two, you have two separate points you're making here, but I just was trying to explore the exceptional circumstances.
No, so I would agree with you if you were to have a properly pled factual scenario.
So your point is not, something like this could never be shown to be the kind of harm. Your point is, it just was, the case wasn't made here, primarily, at least your point is the case was just not made in the trial court adequately.
That's right. I mean, essentially, a lot of relies on the appellant's own concessions and what just happens factually between not living with, there's no constructive standing. This isn't a game of horseshoes. It's either standing or no standing. And the DC Council and this court has acknowledged that the plan was to limit the number of potential third-party individuals that could apply for standing.
Well, I guess I'm a little unsure because that shifts us over perhaps at least to point 13, which we haven't directly discussed yet, I don't think, in your argument. I guess whatever you think about the legislative history, the wording of it, and I know that for the argument up to this point, you're a big proponent of plain language. So, I mean, the wording of 0.13 is nothing in this chapter, which includes 0.02, shall be construed to limit the ability of any person to seek custody of a child, under an equitable cause of action. So it seems a little hard to say that whatever might have existed before this statute in equity, one has to view it as limited by decisions that were made in setting the criteria in 02, because the legislature seemed to say directly, don't interpret it that way. That's not what we mean. So why doesn't, to the extent your argument is you need to read 13 narrowly in light of 02, I guess I see a plain language difficulty with that. I'm interested in your thoughts about it.
And I think this issue in terms of savings clauses has been addressed both through longstanding Supreme Court case law as well as this court as recently as Overdrive, where you have a savings clause, which in many ways it's just to show that, okay, well, we're not going to preempt previous causes of actions, whether or not it's a neglect. So now that we've had this new statute that involves third-party custody, we're not going to preempt, for instance, adoption or neglect third parties being able to have a cause of action under those things. And then including, okay, well, common law and equitable causes of action. And what we said, and what you said in Overdrive was that you have to specify some type of freestanding cause of action. You can't just say, well, court, you have the equitable jurisdiction here to control, what happens. And because of fairness reasons, and for potential harm reasons, that you can go back and rewrite the law.
What was the wording of the savings clause in overdrive? Was it similarly expansive?
Well, yes, I have. I believe it was something to the extent of supplementing.
Which seems a lot, seems a fair bit different, I guess.
You have, I don't have it right in front of me, but it does.
I do remember the word supplementing.
Right, it talks about supplementing, but I think that's also where AT&T comes into play, where the Supreme Court said that. And there was a savings clause of the Communications Act, section 414, that said nothing in this chapter shall in any contained, nothing in this chapter contained shall in any way abridge or alter the remedies now existing in common law or by statute, but the provisions of this chapter are in addition to such remedies. In there, the Supreme Court said in citing a 1907 case, the savings clause cannot in reason be construed as continuing in customers a common law right, the continued existence of which would be absolutely inconsistent with the provisions of the act. In other words,
That's certainly fair, but I guess what I end up wondering is whether the right way of looking at these two provisions together is that the legislature in 02 said, look, here are some, I probably thought they were simpler than they turned out to be in practice, but here are some kind of straightforward situations where we're going to say, yes, third-party custody, you don't have to worry about actions and equity or all that. Here's a safe harbor. If you can meet these, you're in. And then 13 says, yeah, but we have this prior law where you can come in and say, in equity, I should be able to seek custody of a child, and we don't mean to limit that. I don't know that any giving that its prior scope would be contradictory to or incompatible with the fact that certain criteria were specified as a matter of law to be adequate in 02. So I'm not quite sure why the sort of positive contradiction line of authority would mean that we should read the equitable authority more narrowly after the statute than we would have read it before the statute. Now that poses the question of what the heck was it before the statute, which is a fair question, but
right. I mean,
but it is your argument that you think we should be reading it more narrowly after the statute than we would have read it without the existence of the statute, or am I missing, am I misreading?
yeah, so we do have to read it more narrowly. I think part of the problem here is that, as in overdrive, for instance, the appellant hasn't presented a freestanding cause of action that would apply to a central stranger, somebody in Mr. Bolding's position who had a child for 8 days, did not have the child within his purview, living with the child at the time, and was able to still have some type of equitable relief. I mean, those cases that were cited by appellant both involved third parties who already had, where the child was already living with them, whether or not it was Shelton or whether or not it was Rutledge or any other case they might have cited, or any case that, for instance, Judge Deal was looked up and found nothing. I mean, essentially you're in deja vu land with overdrive, where you are basically told to, okay, you have plenary inherent jurisdiction, equitable jurisdiction over this case, and you should find a cause of action that would allow, invent a cause of action that would allow Mr. Bolding to have an exception under the rule. And
So here, and I get hung up in differences, conceptual differences between standing and cause of action, which I confess I don't feel like I fully understand at all. But if you look at our common law equitable cases, which don't refer to standing and aren't really so much like talking about causes of action or standing or any of those concepts, but you just look at what happens is people come in and, I mean, there's a general statute that gives the Superior Court authority to determine the custody of children. And that was treated as a prior authority anyway. And people come in and without sort of saying, oh, well, you don't have a cause of action unless you meet certain criteria. Here's what they are. You can't be a stranger. You've got to have X or Y. I mean, I didn't find any case where we said, sorry, you're just, why are you here in court today? You must leave. We're not going to consider your claim. They just, start adjudicating what they think should be done. Now, none of them go anywhere near as far. I take your point completely that none of them involve someone whose connection to the child is comparable to Mr. Bolding's. That's fair in terms of its magnitude or lack thereof. So that's fair. But I guess I find it a little unclear whether what's going on there is no equitable cause of action, whether it is you can come in, it's just you're losing on the merits because I think it's quite clear that if someone in 1806 said, or if that's a reasonable year to pick, had come in and said, my neighbors have 2 kids, I would like to have custody of them. They seem like great kids and I think I'd be a great parent. If you filed an action like that in equity, you would not have gotten relief. That seems very obvious to me. Whether that because you lack standing or you don't have a cause of action in equity, or whether you have a cause of action, but your cause of action completely fails on the merits, because of course, no one is going to just on a best interest of the children take away the rights of parents. Not sure. So that's where I find myself a little unsure about what to make of the prior common law. It certainly doesn't create any guardrails, to use a term that was used in a different setting. It's just kind of like people come in and they say, there are some children, they don't know that, their situation is bad. I would like you to declare me their parents. And we do it. We did it, or our predecessors did, without sort of saying, oh, here are the criteria. Here's the cause of action that we're recognizing. It's called equitable parentage. Here are its prerequisites. We just sort of, without paying a lot of attention to the conceptualizing it, we just sort of did it without ever saying, sorry, you're out of court before we even get to the merits of any claim because you lack something that's fundamental. We just don't seem to have done that.
That's right. But I think what's important here is that you have a very specific statutory scheme that was developed by the DC Council, that was, draft after draft was discussed, to where you had the standing provision, which started out as broad as, well, any third party can file for custody. And it's up to the court to discern, the trial court to determine whether or not they should have standing. To the next version, which was, well, you have a number of different ways, including consent, if the child doesn't live with the parents, and if there's other kind of unfitness criteria that many parties said, well, that's more neglect. And then you had a final catch-all, which was other extraordinary circumstances. And then you ended up with what we have here. And the council eliminated that catch-all, which was an actual catch-all. So what we have here with the savings clause, that is not the equivalent of what was in the previous draft of this legislation, which was under D, any other extraordinary or exceptional circumstance for which a trial judge can use its discretion and have its authority to determine that a third party could just jump into a case. And I think that's why you have this narrowing. And when you have a very specific statutory scheme, and that's why when this court wrote overdrive, it specified in saying, if you have this specific statutory scheme, you can't just have this equitable plenary authority to run roughshod over this scheme that's already been put in place.
So what if we had a case very similar to this one, but say it's from 1924, and it just so happens to have the same names. It's called Bolding, and in that case, some judges in one of our predecessor courts said, there's a forfeiture by wrongdoing type of, the parents who committed wrongdoing like this, they forfeit their right to custody. And in cases like that, we look for, the next of kin of the deceased to stand in their shoes. And that was something that was just codified, and then occasionally would be referred to as the Bolding Doctrine over the years. And then the statute's passed, and it says, we're not displacing common law, equitable jurisdiction, but they also make no mention of this sort of forfeiture by wrongdoing, and then next of kin gets preference to decide custody. Do you think that doctrine would have survived passage of the statute?
No. I
You don't think so?
I don't think so. I would agree that you're getting closer in terms of having a cause of action that appellant or anybody could point to and say, well, here's a specific cause of action. It wasn't specified within or necessarily preempted by this third party custody, Safe and Stable Homes Act. But at the same time, there's still a strong argument that an act doesn't destroy itself. So
that wouldn't destroy itself. That would be a very, very narrow carve out based on a firmly rooted exception. Basically, at least that's how I try to craft the hypothetical. I guess, what is 0.13 doing then? Like what good What good is it to, why write it?
I mean, I think it ultimately says, for instance, if there was any kind of question in savings clauses are consistently seen in repealing statutes and many different types of civil statutes to make sure that there's not going to be any confusion as to this cause of action supplanting other legitimate and valid causes of action. For instance, somebody could argue, well, now that we have third-party custody under 16831 at all, now we no longer have potential third-party custody under the neglect statute. Third parties have to go through this chapter of this title, and third parties wouldn't be able to go through, for instance, adoption. They'd have to go through this chapter first. So I think that's one of the main reasons why you have this type of savings clause. But again, we have the law and common sense and whatever authority you want to point to would say that you have to have harmony between the cause of action that you're pleading and the statutory scheme that's very specific is what we have here. Again, that the DC Council very carefully crafted to eliminate any type of catch-all and to have very strict criteria for you to be able to achieve standing.
And I give you another hypothetical to see how far you'll take that line of thinking. So imagine that a child has been living with a grandparent in every sense of living, like residing. The grandparent has been, although the grandparent doesn't have legal custody, both parents have been out of the picture for several years. And the child has been living with the grandparent for several years. And then one of the parents kind of says, I'm ready to, play my legal role, and takes custody of the child and has had the child for the last 3 months.
If the parent takes the child.
The biological parent takes the child. And the grandparent comes to believe that the child is being abused by the biological parent, who has kind of resurfaced and taken day-to-day physical custody of the child. And for whatever reason, CFSA is not in the picture, but believes that like very serious abuse is being committed. And comes in under, can't meet the requirements of 83102 because isn't living now with in any normal sense of the term, and hasn't been for 4 of the preceding last 6 months of the child's life. So then comes under 13 and says, I have a cause of action. I have a very strong bond to the child. It's basically like in a way, like some of the prior cases that your opponent relies upon, and says, I have an equitable cause of action, and you need to determine whether after you inquire into it, at the end of the day, what I believe is that I should lawfully be given custody of the child. Would you say, and obviously, depending on what substantive determinations were made there might be constitutional limitations on what relief could be granted in such a proceeding. I get that for sure. But would you say that you think that that's not a viable claim under Section 13 because although there were cases like that before, you have to read 02 and the legislative history of it as really cutting back on cases like that?
Yes, I would agree with that. But I think as harsh as it may seem that individual would not have standing based on the scheme that DC Council has carved out. I mean, I think it's hard to say.
You're saying that setting the only hope is the neglect process.
Yes,
Why not-
right.
why not-
I was about to say that.
Mr. White, why not 0.03? Why not the de facto parent?
Right, that
thing,
was
right. Isn't that kind of the closest thing to what existed in the prior case law? Is you have de facto parent standing, and that's totally independent of 0.02.
right. But so my memory is not so great. So I was trying to think in my head exactly what the grandparent was going through. But right, you have the de facto parent, and in fact, that would go through 16 chapter 9, which would just talk about the divorced parents and unwed parents and what like that and whatnot. So and then you have CFSA. It's hard to divorce them, so you have the neglect action, and you have actions under de facto parentage. I see that my time is well up. If the court has no further questions, I would ask this court to affirm. Thank you.
Thank you very much. Ms. Leyba, am I pronouncing that correctly? We'll give you 4 minutes.
Thank you, Your Honor. If you would permit me 3 brief responses to appellees before I take further questions. First, where this court is grappling with the definition of living with, as clearly the parties have been as well, the statutory interpretation rules of this court are that the court should construe to avoid an obvious injustice. And so that's one helpful instruction that we can apply here. Second, the court may look to the emergency motion, not just the complaint. And the allegations at this stage, or at the motions to dismiss stage, should be taken as true. So even if appellees want to characterize them as speculative, as conjecture, we need to figure that out at the next stage, not here. So the next stage is where we have the opportunity to take evidence where this court can provide an equitable forum to determine whether the allegations of PTSD are true or if they're just speculative and SM has been safeguarded. And 3, in brief, as Judge McLeese raised, not only is the language of point 13 expansive, but we have an additional instruction from the DC Council in the legislative history where, quote, this savings clause establishes that the statutory cause of action is in addition and does not supplant common law or other rights and remedies. And I highlight this to say that it's about adding, not subtracting, when we're trying to understand what 831.13 means, given the history of common law and some of the cases that we've highlighted for your honors today.
Can I ask you about, I think your second point, which was about the idea that you're not really limited to the complaint, but you also should be, your opposition to the motion to dismiss for lack of standing should be taken into account. And then sort of invoking the general dismissal standard. I'm a little unsure about that, given 831.02A1C, the last part of it that says, provided that the complaint or motion,
Complaint or motion?
and the motion is motion to intervene.
Motion for emergency custody here. Yes, Your Honor.
Well, it's a little unclear to me. A1 refers to a party may file a complaint or a motion to intervene. And then I had thought that the references in A1C to the complaint or motion meant to the complaint or the motion to intervene. But in any event, it says shall specify in detail why the relief is necessary to prevent harm. That suggests that maybe the kind of ordinary motion to dismiss standard may not be applicable and that there's some sort of a requirement of more specific pleading. Do you disagree with that? Or it just doesn't seem entirely obvious to me that sort of notice pleading under the Twombly-Iqbal standards is what we'd be looking at rather than something that might be more specific and required by statute here.
In response to that, Your Honor, I would just take a step back and think about how these cases really proceed through the court system. And that's largely pro se. In child custody, we don't have these sort of like strict and fast evidentiary rules. Parties are proceeding without the advice of counsel. And Judge Israel makes this point in one of the hearings that it's not uncommon in these types of cases to see pleadings that are sometimes somewhat bare because the parties are proceeding pro se. And as far as the question of what can this court look at, whether it be a motion to intervene or someone else, I would point the court again to Pleasant, where there the court looked at an emergency motion for custody, which is what Mr. Bolding also filed here. If there are no further questions from your honors, another point I just wanted to quickly highlight is that this was not the passive death of a parent. It's not just that one parent survived, but that Mr. Mack killed Miss Ward. And had mom survived, and amicus brief makes this point, there would be a presumption against his taking custody. And so this is another equity that we just wanted to raise before your court before my time was done with you. And so looking forward at the form of relief requested here, there are 2 potential paths this court can go down. First, the court can remand with instructions to recognize Mr. Bolding's standing so that there is a forum where evidence can be collected to determine what is in SM's, what can be, how we can protect SM from harm. Following this path safeguards SM. Alternatively, the lower court order can stand undisturbed and there will be no independent arbiter to protect SM. The court's role will end when the appellate decision is written. And so we ask that this court reverse the Superior Court's ruling below and remand this case for proper application of the district's custody laws consistent with the opinion of this court. Thank you.
Thank you, Ms. Leyva, Mr. Whitehead, for your briefing and your arguments today. The case will be submitted and we are adjourned.
All right. Rise. This honorable court, now adjourned.